What are you going to do if you believe that your loved one's last will and testament is in a safe deposit box? Hi, I'm Guy DeMartino. I am a Northwest Indiana estate planning and probate lawyer, and I'd like to give you some tips because this recently was a situation that I had to deal with. So come back with me. Somebody calls my office. One of their loved ones passed away. They can't find the original will, and they believe that it is in a safe deposit box in one of the local banks. What do? Well, these are the steps that you need to go through in order to determine. The first thing that I would do is I would go to the local banks or the bank that your loved one passed away, the bank that your loved one banked at the time they passed away. And I would say, here's a copy of the will, or explain who you are, and then ask them if you or somebody in the family has signing rights or the ability to enter the safe deposit box if they want. They might not tell you anything, but if there is somebody in the family that is authorized, an authorized user for the box, they will go ahead and reach out to them. Be sure to go in with a copy of the death certificate. Okay. If you don't have any luck there, and you do have a copy of the will, these are the things that you could do. Number one, you can petition the court, and you can ask the court if you are able to find an actual safe deposit box that is owned by your loved one for an order to the court to drill the safe deposit box. They will drill it. They will inventory it based on the court order. You will have to pay the locksmith and the costs for drilling the box. It's the first thing. Second thing you can do with the court is you can petition the court to accept the copy of the will that you have, especially if you are able to go ahead and to identify the witnesses, if it was a self-proved will, and get affidavits from those witnesses that they were there, that is their signature, that they recall the will being signed. The problem with that, or the difficulty with that, is that one of the ways that somebody can revoke a will is just by tearing it up and throwing it away. So the court might be saying, hey, this will could have been revoked. On the positive side, if the will is a standard will and follows the statutory requirements that we would have if somebody doesn't have a will, and you're able to come forward with witnesses saying, yes, I was there, and I never heard this person revoke the will before they passed away, the odds are that the court will accept the will, the last will and testament, into probate, and you will be able to proceed. If you can't, then you're going to have to proceed in court as if there was no will under the intestacy laws of the state of Indiana. So that's the process that you would have to follow if you can't find the original will and you think that the will is in a safe deposit box. I'm not a big fan of safe deposit boxes because of these problems. If you have any questions, you can always reach out to me. I am Guy DeMartino. Have a great day.